The gavel slammed down. Final. Definitive. My legs buckled as the word guilty echoed through the courtroom. 25 to life for a murder I didn't commit. I searched the jury's faces, 12 strangers who now controlled my destiny. None would meet my eyes. My attorney's hand gripped my shoulder, his whispered will appeal hollow against the roar in my ears. As they cuffed me, I caught sight of District Attorney Pearson collecting his papers, that slight smile on his lips. Not the satisfaction of justice served, something else. Something calculated. The same expression he'd worn when he'd accidentally mentioned my prior misdemeanor arrest to the media, knowing it would be splashed across tomorrow's headlines. What I didn't know then, as they led me away from my sobbing mother, was that Pearson had already buried the evidence that would have freed me, long before I ever set foot in that courtroom. Before everything fell apart, I was Miguel Reyes, 34, a senior prosecutor with the county DA's office. The irony isn't lost on me. 8 years building cases against the guilty, only to become another statistic, another innocent man trapped in the system I once proudly served. My apartment in Oakland wasn't fancy, but it had a view of the bay that made the long hours worth it. I'd moved there after my divorce from Sophia 3 years ago. Amicable enough, but we'd grown apart while I climbed the ranks. No kids, thankfully. That would have made everything harder. My parents had come from Mexico in the 80s, worked themselves to the bone for their American dream. Dad still ran his auto shop in East Oakland, and Mom taught ESL classes at the community center. They'd beamed with pride at my law school graduation. Our son, the attorney, they'd say to anyone who would listen. The first Reyes with a professional degree. The Monday before everything changed, I'd been called into D.A. Warren's office. "Miguel, you've got a real future here," he'd said, leaning back in his leather chair. The Sanderson case was a tough one, but that conviction was solid work. He mentioned the upcoming election for his position. He was retiring, and how he thought I should consider running. This office could use some new blood, someone who understands different communities. I'd left floating, called my parents right away, even called Sophia, who genuinely congratulated me. Later that night, I met my best friend Carlos for drinks. To the future district attorney, he'd toasted, beer bottle raised high. Carlos and I had been friends since law school. He'd gone private practice, corporate law, made 3 times my salary but always joked he couldn't sleep at night defending corporate vampires while I got to be a hero. That night, he'd introduced me to his new girlfriend, Veronica. Pretty, sharp, worked in the public defender's office. We'd debated the merits of a new sentencing reform bill, all in good fun. She was passionate, articulate. I liked her immediately. Work had been busy that week. A string of convenience store robberies had the city on edge, and a high-profile drug case against local kingpin Darius Jackson was hitting roadblocks. Key witnesses suddenly forgetting what they'd seen. I'd stayed late most nights, my desk drowning in paperwork. Thursday evening, I'd been reviewing evidence for the Jackson case when Officer Reynolds dropped by. We weren't friends exactly, but we'd worked dozens of cases together over the years. Reliable cop, if a bit too eager sometimes. "Reyes, got a minute?" He seemed tense, shifting from foot to foot. "That confidential informant for the Jackson case? Torres? Found him dead this morning. Single shot to the head." I remember feeling sick. Torres had been reluctant to testify, afraid of retaliation. I'd assured him we'd protect him. "Any suspects?" I'd asked. Reynolds had shrugged. "Jackson's crew, obviously, but no witnesses, no evidence yet." "Keep me posted," I'd said. "And Reynolds?" "Let's keep this quiet for now." He'd nodded before leaving. I hadn't known then how that conversation would be twisted against me later. Friday evening, I'd left work early for once, stopped at Gallo's wine shop on Telegraph Avenue, picked up a bottle of Cabernet. The elderly owner, Mr. Gallo, had greeted me by name. "Big weekend plans, Mr. Prosecutor?" he'd asked with his usual friendly smile. "Just unwinding," I'd replied, paying cash, a habit from my college days I'd never broken. The security camera above the register had silently recorded our exchange. That footage, me, at that specific shop at that specific time, would later become the prosecution's linchpin. Later that night, I'd ordered takeout, watched a Warriors game, and fallen asleep on the couch. My phone had died. Something else that would later seem suspiciously convenient to investigators. What I didn't know was that across town, in a parking garage near the courthouse, someone was committing the crime that would destroy my life. Someone was murdering Darius Jackson, the man whose case I was prosecuting, with a 9mm handgun, the same caliber as the service weapon I kept locked in my bedroom safe. If I'd worked late that night, if I hadn't stopped for that bottle of wine, if someone had seen me enter my apartment building, maybe I'd still be free today. Instead, the security camera at Gallows would be the last confirmed sighting of Miguel Reyes, upstanding citizen, before he became Miguel Reyes, accused murderer. When I see my reflection now, I sometimes still catch glimpses of the clean-cut prosecutor I once was. But those glimpses are fading, replaced by the harder eyes of a man who's learned the system can fail anyone, even those who once upheld it. The knock came at 6:17 a.m., 3 sharp raps that jolted me from sleep. I stumbled to the door in sweatpants and a t-shirt, hair disheveled, expecting a package delivery or maybe an overzealous neighbor. Instead, 4 police officers stood in my hallway. I recognized Detective Morris immediately. We'd worked the Harrington homicide together last year. "Miguel Reyes?" he asked formally, as if we were strangers. "We need you to come with us to answer some questions." "Questions about what?" I asked, confusion giving way to the first flickers of concern. "Just routine, better discussed at the station." I knew enough about routine questions to feel uneasy, but I also believed in the system. I believed in my innocence. "Let me change quickly," I said. Morris nodded. "We'll wait right here." At the station, they put me in interview room 3, the one with the better recording equipment. I noticed but wasn't concerned. I still thought this was all some misunderstanding that would be cleared up within hours. Morris entered with Detective Sanchez, a woman I knew by reputation but had never worked with directly. They set a recorder between us. "For the record, you're not under arrest," Morris began. "You're free to leave at any time." I nodded, relaxed slightly. "What's this about?" "Where were you last night between 10 p.m. and midnight?" "Home, watching the Warriors game. Ordered Chinese food around 9. "Anyone with you? Anyone who can verify that?" The question sent the first real chill through me. No, I was alone. Sanchez slid a photograph across the table. Darius Jackson, eyes open but unseeing, a neat hole in his forehead, lying sprawled beside a silver Mercedes in what looked like a parking garage. "Darius Jackson was murdered last night," Morris said flatly. "Shot once in the head." My stomach dropped. I'm prosecuting his case." "We know," Sanchez replied. "Which gives you quite the motive, doesn't it?" The question caught me off guard. "Motive? I don't understand." "Jackson's lawyer filed a motion yesterday afternoon claiming prosecutorial misconduct. Alleged you'd been withholding exculpatory evidence. Judge Watkins was going to review it Monday morning." Morris leaned forward. "That would have been embarrassing for an up-and-coming prosecutor with political ambitions, wouldn't it?" My head spun. There had been no misconduct. Jackson's attorney was grasping at straws. That's absurd. The motion had no merit. "Maybe," Sanchez said. "But now we'll never know, will we? Because the defendant is dead and the case goes away." The interview continued for hours. They circled back to the same questions repeatedly, trying to trip me up. When had I last seen Jackson alive? Did I own a gun? Where had I gone after work? Had I spoken to Officer Reynolds about Torres, the murdered informant? I answered truthfully, calmly at first, then with growing agitation, as the nature of their suspicion became clear. "I want to call an attorney," I finally said. Morris smiled thinly. "Thought you were innocent, counselor." "I am innocent. I'm also not stupid." They let me make the call. I phoned Carlos, who promised to come immediately. While waiting, they placed me in a holding cell. For privacy, they claimed. The metal bench was cold, the walls too close. For the first time, real fear gripped me. Carlos arrived looking disheveled but alert. "They're searching your apartment right now," he whispered after the officers stepped away. "Miguel, this is serious." "I didn't kill anyone," I insisted. "I know, but they think they've got physical evidence. Your gun is in my safe. Hasn't been fired in months. They're saying it's missing." My blood went cold. That was impossible. No one had access to my safe. No one knew the combination. Things moved quickly after that. The search team claimed they'd found gunshot residue in my bathroom sink. A witness, never identified, reported seeing someone of my build and complexion near the parking garage. My proximity to the case, the alleged misconduct claim, the missing gun, suddenly I was no longer answering routine questions. I was being arrested for first-degree murder. The media descended like vultures. "Prosecutor turns murderer," screamed the headlines. An old photo from college surfaced. Me at a party looking drunk, giving the camera the middle finger. That became the image plastered everywhere. Not the dozens of professional photos from my years serving the public. A reporter dug up my decade-old arrest for disorderly conduct during a law school party. Charges that had been dismissed but now painted me as someone with a history of violent behavior. The evidence mounted with suspicious convenience. My cell phone records showed my phone had been turned off during the critical hours. Because the battery had died, I explained, but they suggested I'd done it deliberately to avoid tracking. The wine shop security footage placed me near enough to the crime scene to make it plausible I could have committed the murder. The cab driver who'd dropped me at my apartment building that night couldn't be located. Most damning was the ballistics report. Jackson had been killed with a 9mm, the same caliber as my missing service weapon. Not conclusive by any means, but enough for the media to run with. Officer Reynolds' statement twisted our conversation about Torres into something sinister. According to him, I'd seemed unusually interested in keeping Torres' death quiet and had asked suspicious questions about the investigation. Carlos fought hard for bail, but Judge Martin, a law and order hardliner, denied it, citing the heinous nature of the crime and my substantial flight risk as someone with connections abroad. My Mexican heritage, never before relevant to my professional standing, suddenly became evidence of foreign ties. My parents mortgaged their home to help pay for my defense. Carlos recommended a top criminal attorney, Nathan West, who took the case at a reduced rate. Professional courtesy, he called it, but I saw the doubt in his eyes when we reviewed the evidence. The DA's office, now led by interim DA Pearson, who'd always resented me, pushed for a quick trial. "Justice delayed is justice denied," he told reporters, without a hint of irony. In my cell at night, I replayed every moment, searching for what I'd missed. Who had taken my gun? Who had set me up so thoroughly? And why? The answer came 6 weeks into my detention, when Veronica, Carlos's girlfriend from the public defender's office, visited. She slipped me a note during her visit, hidden in case files. It read, "Pearson buried evidence in the Rodriguez case last year. I found proof. Was going to report it when you became DA. He knows. Be careful." As she left, our eyes met briefly. In that moment, I understood. This wasn't just about Jackson. This was about power, ambition, and a man willing to destroy an innocent life to protect his career. But understanding my enemy didn't help my case. As the trial date approached, West delivered the crushing news. "They've found your gun, Miguel. In a storm drain 3 blocks from the garage, ballistics match. And there's more. They've got a witness who says they saw you arguing with Jackson 2 days before the murder." The witness was lying. The gun was planted. The evidence was manufactured. But proving it would require resources and influence I no longer had. When they led me into court for arraignment, I saw Pearson at the prosecution table, his expression neutral, but his eyes triumphant. And I knew then that my fight for justice would be the hardest case I'd ever faced. My trial began on a Tuesday morning in June. The courtroom was packed, media, curious attorneys, law students studying the spectacular fall of a once promising prosecutor. Judge Wilson presided, a conservative jurist known for his harsh sentences. I entered wearing a navy suit Carlos had brought, my own from before. But the illusion of normalcy was shattered by the clink of chains around my ankles and the deputies flanking me. The jury would be told to disregard these security measures, but the visual message was clear: dangerous criminal. The jury selection revealed the first major structural disadvantage. From a pool of 60 potential jurors, only 4 were Latino, and none made it onto the final panel. My jury consisted of 9 white jurors, 2 Asian Americans, and 1 black woman, none from neighborhoods like the one where I'd grown up. The prosecution used peremptory challenges to strike the 2 Latino jurors who'd advanced to the final round, citing unrelated concerns about their suitability. West objected, citing Batson v. Kentucky, but Judge Wilson overruled him, accepting the prosecution's paper-thin explanation that the strikes had nothing to do with ethnicity. Pearson himself led the prosecution, unusual for a DA, but a sign of how personally invested he was in my conviction. His opening statement painted me as a prosecutor who'd crossed the line, who'd become drunk on power, and took the law into his own hands when a case threatened to damage my reputation. Miguel Reyes isn't on trial because he's a prosecutor, Pearson told the jury, his voice dripping with false regret. He's on trial because the evidence, overwhelming evidence, proves beyond any reasonable doubt that he executed Darius Jackson to save his own career. West's opening focused on the lack of direct evidence, the circumstantial nature of the case, and the rush to judgment. The prosecution has constructed a narrative, he argued. But narratives aren't evidence. Look for what's missing in their case: eyewitnesses to the actual crime, surveillance footage of my client at the scene, a clear timeline that accounts for every movement. Those gaps aren't technicalities, they're reasonable doubt. The prosecution's case unfolded methodically. The crime scene technician testified about the ballistics match to my gun. The detective detailed finding gunshot residue in my bathroom sink. A parking attendant placed someone of my general description near the garage that night. My cell phone records showed my phone was inactive during the critical period. But it was the testimony of Trevor Reed, a former client of Jackson's, that seemed to seal my fate. Reed claimed he'd overheard me threaten Jackson outside the courthouse 2 days before the murder. He said, "This case is going away one way or another," Reed testified, his prison tattoos visible beneath his dress shirt. Jackson laughed it off, but Reyes looked serious. Cold, you know, like he meant business. The conversation had never happened. I'd never spoken to Jackson outside of official proceedings. But Reed's testimony, likely bought with promises of leniency in his own pending cases, gave the prosecution the direct evidence they needed. West cross-examined effectively, exposing Reed's extensive criminal history and pending charges, but the damage was done. The jury had heard someone directly connect me to threatening the victim. Our defense strategy centered on creating reasonable doubt and suggesting an alternative theory, that Jackson was killed by rivals in the drug trade. We called witnesses who testified about threats Jackson had received from competing dealers. We highlighted inconsistencies in the police investigation, particularly their failure to interview key figures in Jackson's organization. Our strongest moment came when West questioned Detective Morris about the investigation's timeline. "Detective, from the time of Mr. Jackson's murder to Mr. Reyes's arrest, how many other suspects were interviewed?" Morris shifted. 2 or 3. 2 or 3, in a high-profile murder case? And how many hours of investigation were devoted to these other suspects? I don't recall exactly. Would reviewing your case notes refresh your memory? Morris glanced at Pearson. They would. West handed him the police reports. Please tell the jury how many hours were spent investigating other suspects. After reviewing the documents, Morris answered reluctantly, 4 hours and 20 minutes total. And how many hours were spent investigating Mr. Reyes before his arrest? Approximately 36 hours. So from the very beginning, this wasn't an investigation to find a killer. It was an investigation to build a case against Miguel Reyes specifically. Objection, Pearson shouted. Argumentative. Sustained, Judge Wilson ruled. But the point had landed. At least I thought so. Our case suffered a critical blow when Judge Wilson ruled that Veronica's evidence about Pearson burying exculpatory evidence in previous cases was inadmissible. The alleged misconduct in unrelated cases is not relevant to the facts of this murder, he declared, despite West's passionate argument that it established motive for framing me. The most painful testimony came from Officer Reynolds, once my colleague. On the stand, he described our conversation about the Torres murder in ominous terms. Reyes seemed unusually interested in keeping it quiet, Reynolds testified. Asked me not to file a formal report yet. At the time, I thought he was just being cautious about the Jackson case, but looking back, he paused dramatically. It seems like he was already planning something. I watched the jury's faces as Reynolds spoke. They believed him. They saw me not as a dedicated prosecutor who wanted to handle a sensitive case properly, but as a calculating killer laying groundwork for a murder. When I took the stand in my own defense, against West's advice, I spoke directly to the jury. I explained my work, my dedication to justice, the absurdity of throwing away my career and freedom over a routine case. I denied threatening Jackson, denied shooting him, denied every element of the prosecution's theory. During cross-examination, Pearson approached me with predatory confidence. "Mr. Reyes, you testified that you've always followed the law and respected proper procedure. But that's not entirely accurate, is it?" He picked up a document. "You were arrested in law school for disorderly conduct, were you not?" West objected. The charges had been dismissed. But Judge Wilson allowed the question. "Yes," I answered. "At a campus party when I was 23. The charges were dismissed." "And as a prosecutor, you've had ethics complaints filed against you, correct?" 2 in 8 years, both dismissed as unfounded. "Just like you claim these murder charges should be dismissed?" Pearson smiled. No further questions. The deliberations lasted just 7 hours. When the jury filed back in, none would meet my eyes, the universal tell. The foreman, a retired banker, stood. "On the charge of murder in the first degree, we find the defendant, Miguel Reyes, guilty." The courtroom erupted. My mother wailed. Carlos put his head in his hands. West immediately began discussing appeal options, but I heard nothing past that word. Guilty. The room seemed to tilt and narrow. Guilty. The word I'd sought for countless defendants, now attached to me, forever. At sentencing the following week, Judge Wilson showed no mercy. "You've betrayed not only the victim but the entire justice system you swore to uphold," he intoned. "I sentence you to 25 years to life in state prison." As the deputies led me away, Pearson gathered his papers, that same slight smile on his lips. Our eyes met briefly. No words were necessary. He had won. I had lost, and the truth lay buried beneath a perfect frame. The news coverage that night called it justice served and proof that no one is above the law. An ironic phrase, given what had really happened. Because the law had been manipulated, justice perverted, and I was paying the price. San Quentin swallowed me whole. Processing was a deliberate dehumanization. Strip search, delousing spray, prison-issue clothing, ID number stamped on everything, including me. My name became irrelevant. I was now inmate in a 45873. "Former prosecutor, right?" the intake guard said, smirking as he handed me my bedroll. "Better keep that quiet in general population." But secrets don't exist in prison. By my first night, everyone knew exactly who I was and what I'd done for a living. The whispers followed me to the cell I shared with Marcus, a burglary offender serving his 3rd stretch. "You're in trouble, prosecutor," he muttered after lights out. "Lot of guys in here you put away." Sleep was impossible that first night. The constant noise, the stench of industrial disinfectant barely masking other smells. The knowledge that I was surrounded by men with every reason to hate me. Morning revealed San Quentin's unofficial but rigid racial geography. The yard, the dining hall, the work assignments, everything divided along color lines. As a Latino, I was expected to align with the Hispanic prisoners. They approached me on my 3rd day. "You're with us now," said a heavily tattooed man named Lobo. Not a request, a statement of fact. We protect our own, even a former prosecutor. But you contribute, understand? The contribution was smuggling contraband through my work assignment in the laundry. I refused. The beating came that night. 4 men in the shower, no guards in sight. 3 broken ribs and a concussion earned me 2 weeks in the infirmary, where the doctor asked no questions and offered minimal treatment. When I returned to general population, an older Hispanic prisoner named Esteban approached me. "You need to be smarter," he said quietly. "Refusing Lobo publicly. That's disrespect he can't ignore. Find middle ground or you won't last a year." Esteban became my reluctant guide to prison survival. Don't stare. Don't ask personal questions. Always keep your back to a wall. Never accept favors without knowing the price. I negotiated an uneasy truce with Lobo. I would help other Hispanic inmates with legal paperwork but wouldn't participate in any smuggling. An acceptable compromise, barely. Outside connections frayed quickly. My parents visited every week at first, my mother crying continuously. My father aged a decade in months. Carlos came when he could, bringing legal updates and news from the outside. But my other friends disappeared. Former colleagues pretended they'd never known me. Sophia came once. "I had to see you," she said across the visiting room table, "to know if I could still see Miguel in there." Her eyes searched mine. "I don't know if I do." She never returned. Prison days blurred into an endless routine. Wake at 5:30, breakfast at 6, work assignment from 8 to 4, dinner at 5, lockdown at 9. Within this framework, violence erupted randomly. Shanks fashioned from toothbrushes, beatings in blind spots beyond camera coverage, guards who looked the other way for the right price. The prison library became my sanctuary. I spent every available hour there, studying case law, learning about wrongful convictions, post-conviction remedies, habeas corpus petitions. I wrote to innocence projects, describing my case. Most never responded. 2 sent form letters, due to high volume of requests. 6 months in, a new volunteer started teaching GED classes at the prison. Professor Alan Miller, a retired law school instructor. I enrolled not because I needed education, but because I craved intellectual conversation. Miller recognized me immediately. "You were in the news," he said after class one day. "The prosecutor convicted of murder." "Wrongfully convicted," I corrected. He studied me. "Everyone in here says that. Not everyone was framed by a corrupt DA." Something in my tone must have convinced him to listen. Over weeks of conversations after class, I shared my story, the evidence against me, and my suspicions about Pearson. "Even if what you say is true," Miller said eventually, "proving it would be nearly impossible without new evidence." "I know who might have that evidence," I replied. "Veronica Torres, a public defender. She discovered Pearson had buried exculpatory evidence in another case. The judge wouldn't allow it at my trial." Miller agreed to contact her discreetly. 2 weeks later, he returned with devastating news. "Torres left the public defender's office 6 months ago. No forwarding information." My first real lead vanished. Another setback came when Carlos visited with updates on my appeal. "The court upheld your conviction," he said, his voice flat with defeat. "They found no reversible error in the trial proceedings." I'd expected it, but still felt the blow physically, like a punch to the stomach. The appellate courts rarely overturned jury verdicts, especially in high-profile cases with seemingly solid evidence. "What about the gun?" I asked. "There must be fingerprints on it besides mine." "They found partial prints that weren't yours, but they were too degraded for identification. The prosecution argued you wore gloves." Every path forward seemed blocked. 3 years into my sentence, I received a letter from a fellow prisoner in Folsom, transferred from San Quentin months earlier. "Reyes, you don't know me, but I was in Jackson's crew. Word inside is that Reed, the witness who said he heard you threaten Jackson, was paid to lie. Not by money, but by getting charges dropped on his brother. Check the court records from June 2023. Reed's brother Tony had a 3 strikes case that mysteriously went away right after your conviction. No coincidence, man. Thought you should know. The letter was unsigned. I immediately asked Carlos to investigate. The information checked out. Tony Reed had faced 25 to life on his third strike, but the charges had indeed been reduced to a misdemeanor with time served, just weeks after my conviction. It wasn't proof of my innocence, but it was the first crack in the prosecution's case. Reed had lied under oath about hearing me threaten Jackson. What else was fabricated? My next breakthrough came from an unexpected source. Marcus, my former cellmate, had been released and then rearrested on new charges. When he returned to San Quentin, he sought me out. "Prosecutor," he said, nodding in greeting. "Got something you might want to hear. Did some house burglaries with this guy on the outside. He used to be a crime scene tech for the county. Said your case was weird, evidence logged before it was supposedly found. Like someone knew what they needed and planted it backward." "Did he say who?" I asked, pulse racing. Marcus shook his head. "Nah, but he said the orders came from the top. Take that how you want." I filed a new habeas petition based on these developments, representing myself after my appellate funds ran out. Judge Wilson, the same judge from my trial, dismissed it without a hearing. Prison politics intensified. A race riot left 3 dead. Lockdown stretched from days to weeks. My laundry job was reassigned to the kitchen, punishment for filing too many legal motions. During one lockdown, I received a letter forwarded through Carlos. The return address was a P.O. box I didn't recognize. Inside was a single newspaper clipping about D.A. Pearson announcing his run for state attorney general, and a handwritten note. "Still have what you need. Not safe yet. Watching the news for your case." The handwriting matched Veronica's note from years ago. She was still out there, still had evidence of Pearson's misconduct, but was afraid to come forward while he accumulated more power. 8 years into my sentence, Professor Miller retired from volunteer teaching, but not before introducing me to Justine Weber from the California Innocence Network. "They've agreed to review your case," Miller told me during his final visit. "It's preliminary, but it's something." For the first time in years, I felt a flicker of hope. Maybe the truth wasn't buried forever. Maybe it was just waiting for the right people to unearth it. That night in my cell, I removed a loose brick in the wall where I'd hidden every scrap of information I'd gathered over the years. The anonymous letter about Reed, Marcus's information about the crime scene tech, the newspaper clipping from Veronica. Together they formed the beginning of a path toward freedom. "One day," I whispered to myself as I replaced the brick. "One day the world will know the truth." The California Innocence Network moved with the deliberate pace of all legal proceedings, which is to say, painfully slowly. Their initial review of my case took 11 months. When Justine Weber finally returned, her expression was guarded but determined. "We're taking your case, Miguel," she said across the visiting room table. "There are significant procedural irregularities, and the evidence against you has troubling inconsistencies." She explained their strategy. "First, locate Veronica Torres and secure her testimony about Pearson's pattern of misconduct. Second, investigate Trevor Reed's false testimony and the suspicious case dismissal for his brother. Third, track down the former crime scene technician who'd told Marcus about evidence irregularities." "It's a long road," Justine warned. "The system resists admitting mistakes, especially in high-profile convictions, and Pearson has powerful allies now that he's running for Attorney General." I understood the obstacles better than most. As a former prosecutor, I'd witnessed firsthand how the system closed ranks around its verdicts, how finality often trumped justice when errors were alleged. Statistics showed that exoneration rates for Latino defendants were significantly lower than for white inmates claiming innocence, even with similar evidence. Months passed with little progress. Veronica Torres seemed to have vanished. No social media presence, no bar association records. The crime scene technician denied ever making statements about evidence irregularities, clearly afraid for his job. Trevor Reed refused all interview requests. My first real hearing in years was a disaster. The court had agreed to review the new evidence about Reed's brother's suspicious case dismissal, but the hearing judge, a former colleague of Pearson's, ruled it insufficient to warrant reopening the case. The timing could be coincidental, the judge wrote in his opinion. And even if witness Reed had motivation to testify falsely, the physical evidence in this case was overwhelming. The physical evidence. My gun, the gunshot residue, the phone records, all circumstantial, all potentially manipulated, but a wall I couldn't seem to break through. Carlos, now a partner at his firm, continued to support my case financially and emotionally, visiting monthly despite the 3-hour drive. During one visit nearly 10 years into my sentence, he brought news that rekindled hope. "We found Veronica," he said quietly. "She's been living under her maiden name in Oregon, left California after receiving threats." "Will she help?" I asked, hardly daring to believe. "She's scared, Miguel. Pearson is the leading candidate for Attorney General, but she kept records, documents proving he buried exculpatory evidence in at least 3 cases, including original notes with his handwriting, showing he knew the evidence existed. It wasn't directly related to my case, but it established a pattern of misconduct by the man who'd prosecuted me. It was a start. The Innocence Network filed a new habeas petition, this time in federal court to bypass the state judges with connections to Pearson. They also launched a careful media campaign, focusing on the procedural issues rather than declaring my innocence outright. A young investigative journalist named Maya Chen became interested in the case. Her 3-part series, Prosecutorial Power, examined my conviction alongside other questionable cases Pearson had handled. She uncovered that 3 other defendants prosecuted by Pearson had been exonerated after appeals, a statistically unlikely number. Pearson responded with predictable outrage, calling the investigation a politically motivated smear campaign, and me a convicted murderer attempting to manipulate the media. His office issued cease and desist letters to media outlets covering the story. The pressure affected Veronica's willingness to come forward publicly. "I can provide the documents," she told Justine, "but I won't testify in open court. He has too much power." Without her direct testimony, the documents alone were vulnerable to challenges of authentication and context. We needed more. That more came from an unexpected quarter. A retiring detective named Walsh contacted the Innocence Network after seeing Maya Chen's reporting. "I was junior on the Jackson murder investigation," he revealed in a sworn statement. "The evidence collection wasn't handled according to protocol. The gun supposedly belonging to Reyes, it was logged into evidence before the official search of the storm drain where we supposedly found it." This corroborated what Marcus had heard from the crime scene tech years earlier. Walsh's statement continued. "When I raised concerns about the timeline discrepancy, I was removed from the case and transferred to Vice. Message received, loud and clear, armed with Walsh's testimony, Veronica's documents, and the suspicious dismissal of Reed's brother's case. The Innocence Network secured a federal evidentiary hearing. The judge, Rebecca Kaufman, had no ties to California law enforcement and a reputation for meticulous examination of facts. The hearing was scheduled for March 2035, almost exactly 11 years after my conviction. As the date approached, pressure mounted from unexpected directions. 3 former prosecutors who had worked under Pearson came forward with additional allegations of misconduct. The State Bar opened an investigation into Pearson's practices. His poll numbers in the Attorney General race began to slip. Pearson fought back viciously. His campaign surrogates painted me as a murderer attempting to derail his career from prison, the Innocence Network as radical anti-police activists, and the former prosecutors as disgruntled employees with axes to grind. 2 weeks before the hearing, Trevor Reed recanted his testimony in a notarized affidavit. "I never heard Reyes threaten Jackson," the affidavit stated. "I was coached on what to say by the prosecution team. In exchange, my brother's 3 strikes case disappeared." Reed's recantation made national news. Pearson's office immediately released a statement claiming Reed was now lying. Not then. The hearing itself lasted 4 days. Judge Kaufman allowed testimony that had been excluded from my original trial, including Veronica's evidence of Pearson's pattern of misconduct. Walsh testified in person about the evidence irregularities. Expert witnesses challenged the forensic conclusions about the gunshot residue found in my apartment. Pearson himself was called to testify, He appeared confident, dismissing the accusations as desperate attempts by a guilty man to smear my reputation. But under Justine's cross-examination, cracks appeared in his composure when confronted with document after document showing his knowledge of exculpatory evidence in multiple cases. "These are taken out of context," he insisted, his voice rising. "Standard prosecutorial discretion. Is it standard procedure to write, 'Don't disclose this to defense,' on notes about witness statements contradicting your theory of the case?" Justine asked, displaying an enlarged photocopy of his handwritten note. Judge Kaufman studied the evidence carefully, asking penetrating questions of both sides. When the hearing concluded, she announced she would issue a written ruling within 60 days. Those 2 months were the longest of my incarceration. I barely slept, barely ate. Fellow inmates who had followed the case through news reports offered awkward encouragement. Even some guards, those who had come to know me over 11 years, seemed to hope for a positive outcome. 61 days later, Judge Kaufman's 87-page opinion was released. I sat in Justine's office within the prison, hands trembling as I read the conclusion. Based on the substantial new evidence presented, including testimony about improper evidence handling, the recantation of a key trial witness, and the documented pattern of exculpatory evidence suppression by the prosecuting attorney, this court finds that Miguel Reyes did not receive a fair trial as guaranteed by the Constitution. The cumulative effect of these errors undermines confidence in the verdict. The petitioner's conviction is hereby vacated, and the state has 90 days to determine whether to pursue a new trial. Vacated, not yet exonerated, but no longer legally convicted. Tears I'd held back for years finally broke through. The DA's office, now led by Pearson's successor after he'd taken leave to focus on his campaign, faced a difficult decision. Retrying an 11-year-old murder case with tainted evidence and discredited witnesses would be challenging. The political implications of either decision, retry or dismiss, were significant. Media coverage intensified. Pearson's Attorney General campaign suspended operations. The state bar investigation expanded. 78 days after Judge Kaufman's ruling, the new district attorney announced they would not seek a retrial, citing insurmountable evidentiary issues that would preclude proving guilt beyond reasonable doubt. After 11 years, 2 months, and 17 days of wrongful imprisonment, I walked out of San Quentin a free man. The bright April sun hurt my eyes. Cameras flashed. Reporters shouted questions. My parents, now elderly and frail, waited with Carlos. As I embraced them, I saw Justine speaking to reporters. "This case represents a catastrophic failure of the justice system," she was saying. "An innocent man lost over a decade of his life because a prosecutor was willing to hide evidence, manipulate witnesses, and falsify physical evidence to secure a conviction. This is not justice." I stepped to the microphone, squinting in the unfiltered sunlight, and spoke the words I had rehearsed for years. "The system that I once served failed me completely. But truth is patient and persistent. It waits to be discovered, no matter how deeply it's buried." Freedom was disorienting. The world had transformed during my 11 years behind walls. Smartphones were everywhere. Self-driving cars navigated the streets. Buildings I remembered were gone, replaced by gleaming high-rises. Even Oakland, my home, felt foreign, gentrified in some areas, more desperate in others. Carlos had arranged a small apartment for me, paid 6 months in advance. "Just until you get settled," he insisted. My parents had wanted me to stay with them, but their small house in East Oakland felt claustrophobic after just 2 days. Years in a cell had paradoxically made me crave both open spaces and privacy, neither available in my childhood home. The practicalities of rejoining society proved daunting. My driver's license had expired. My credit was non-existent. The law degree that had defined my identity was meaningless now. The state bar had disbarred me after my conviction, and reinstatement would require years of petitions and hearings, assuming they'd even consider someone with my history. Job hunting revealed the second prison that awaited exonerees. Despite the vacated conviction and the growing evidence of Pearson's corruption, employers balked when they searched my name. One promising interview at a legal consulting firm ended abruptly when the manager recognized me. "I'm sorry, Mr. Reyes," she'd said, not meeting my eyes. "While your case is compelling, our clients would be uncomfortable." Uncomfortable. The polite word for, "We still think you might be a murderer." Even with official exoneration, the stigma persisted. Neighbors in my apartment building avoided the elevator when I entered. A woman pulled her child closer when I passed them in the grocery store. The internet never forgot. My mugshot and the sensational headlines about the killer prosecutor remained just a search away. The racial component added another layer to my struggle. White exonerees faced many of the same challenges, but studies showed they received compensation more quickly and found employment more easily than their Black or Latino counterparts. Media covered their stories more sympathetically, focusing on the injustice rather than rehashing the original accusations. 3 months after my release, I received notice that I qualified for state compensation, $140 per day of wrongful incarceration. The total came to just over $570,000 for 11 years of my life. Before taxes, the process to receive it would take up to 2 years. Carlos urged me to file a civil lawsuit against the county and Pearson personally. "You could win millions," he argued. "Make them really pay for what they did." I was tempted, not for the money, but for the official acknowledgement of wrongdoing. But civil suits by exonerees rarely succeeded, particularly against prosecutors protected by immunity doctrines, and the emotional cost of years more in courtrooms reliving the nightmare seemed too high. Instead, I focused on rebuilding some version of a life. I volunteered with the same Innocence Network that had freed me, reviewing case files and offering insights from both sides of the system. The work gave purpose to my days and connected me with others who understood the unique trauma of wrongful conviction. 6 months into freedom, I agreed to my first public speaking engagement at Berkeley Law School. Standing at the podium before hundreds of future attorneys, my throat tightened with emotion. "The system you're training to join," I began, "is operated by humans with human failings, ambition, bias, fear of admitting mistakes. Remember that every case file represents a human life that can be destroyed by those failings." The speech led to others. I became an unexpected voice in criminal justice reform circles, particularly on prosecutorial accountability. Organizations fighting for systemic change embraced my dual perspective as both former prosecutor and exoneree. My parents found new pride in this advocacy work, though my father's health had deteriorated significantly during my imprisonment. When he died 8 months after my release, the grief was compounded by the knowledge that our last healthy years together had been stolen. The most difficult encounters were with those directly involved in my case. I ran into Detective Morris at a courthouse where I was meeting with Innocence Network attorneys. We locked eyes across the lobby. He looked away first, hurrying toward the exit. I felt no satisfaction in his discomfort, only sadness for the system that had corrupted us both. Pearson faced his own reckoning. His attorney general campaign collapsed under the weight of the ethics investigations. The state bar's proceedings revealed a pattern of misconduct spanning his entire career. He was eventually disbarred, a significant fall from power, though hardly comparable to the years I'd lost. In a strange twist, I received a letter from him 3 years after my release. "I still believe in your guilt," he wrote, "but I recognize that my methods crossed lines they shouldn't have. For that overreach, I apologize." The non-apology went into the shredder. The true killer of Darius Jackson was never identified. With evidence contaminated and witnesses scattered or discredited, the case went cold. Some speculated it was a professional hit ordered by a rival drug organization. Others suggested corrupt officers connected to Jackson's operation. The truth remained elusive, another casualty of Pearson's fixation on convicting me. 5 years after my exoneration, I received an unexpected call from Sophia. We met for coffee in a neutral location, a busy cafe in Berkeley. Time had been kind to her. She'd remarried, had 2 children, built a successful practice as a family law attorney. "I should have believed in you," she said simply. "I knew you. I should have known better." "Many people who knew me had doubts," I replied. "The evidence was designed to be convincing." Still, she insisted. I'm sorry. We parted as friends of a sort, connected by history but separated by the divergent paths our lives had taken. Her life had proceeded on its expected course while mine had been derailed completely. Dating proved complicated. How and when to explain my history became an eternal question. Some women were initially intrigued by my story, seeing me as some kind of tragic hero, only to back away when they understood the real-world implications of my notoriety. Others couldn't move past the lingering what-if question. What if I really had done it? Eventually, I met Elena through my advocacy work. A social worker who specialized in helping former prisoners reintegrate into society, she approached my history with neither morbid fascination nor fearful distance, just practical compassion. Our relationship developed slowly, cautiously, but with a shared understanding of how systems fail the vulnerable. 7 years into my new life, I published a memoir titled Buried Evidence. The book detailed not just my case, but the broader issues of prosecutorial misconduct and the challenges faced by exonerees. It received critical acclaim and reopened public discussion about accountability in the justice system. At a book signing in Los Angeles, a young Latino law student approached my table. I'm studying to be a prosecutor because of your story, he told me. To be the kind you were trying to be, not the kind Pearson was. His words affected me deeply. Despite everything, I still believed in the ideal of justice, still believed the system could work if the right people served it with integrity. Not everyone saw my advocacy as positive. Police unions and prosecutor associations often characterized me as anti-law enforcement. Conservative commentators questioned whether my exoneration was truly based on innocence or merely technicalities. Even some reform advocates kept me at arm's length, concerned that my complicated story might not present a clear enough narrative for their campaigns. The truth was messier than either side wanted to admit. The system had failed catastrophically in my case. But not every prosecutor was Pearson. Not every investigation was corrupt. Meaningful reform required acknowledging both the ideals of the system and its terrible capacity for error. 10 years after walking out of San Quentin, I stood at my mother's grave beside Elena. My mother had lived long enough to see my book published, my name cleared, my new purpose found. But the years of stress and heartbreak had taken their toll on her health. They've taken so much from us, I said quietly. Years we can't get back. Elena squeezed my hand. But they didn't take everything. They didn't break you. She was right, but only partially. Parts of me had broken in prison. My innocence about the system I'd served, my faith in justice as an inevitable outcome, my sense of security in the world. Other parts had been tempered, strengthened through adversity. As we walked away from the cemetery, I reflected on the dual identity I would always carry. Miguel Reyes, the wrongfully convicted, and Miguel Reyes, the survivor who emerged to fight for others trapped in the same broken system. They may have buried evidence to convict me, but they could never bury the truth forever. And now, telling that truth, my truth, had become my life's work. Not the life I'd planned, but perhaps the one I was meant to have.